Members 10:30. Members, good morning and welcome to this meeting of the Wigtown Licensing Board of Tuesday the 27th of August 2024. This meeting is being recorded and will be made available for viewing through the Licensing Board's webpage. Please follow good practice guidance, which includes muting microphones and switching off your video when you're not addressing the meeting, writing speak in the Teams chat function when you want to contribute. Please don't repeat contributions already made by other members. No material should be posted in the chat function if it is intended as part of the discussion. The usual standing orders apply, including that any votes will be undertaken by roll call. All members should speak clearly and directly into the microphone, and when contributing, they should refer to the reports and the relevant pages and paragraph to allow everyone to follow. Please focus contributions on areas where clarification is required or to propose an alternative to the recommendation. Members may notice that when calling members to speak, I will refer to them formally using their title, e.g. Councillor Smith, so that it is clear who the councillor speaking are and who by the process of elimination are officers. So members, moving on to item number 1, Sedgent apologies and convener's approval of remote participation, which I approve of. Clerk, can you go through the Sedgent, please?
Good morning, convener, and thank you. I can see that we have all members of today's board present. Yourself, convener, Councillor Dashford, Councillor Hagman, Councillor Hill, Councillor Ingalls and Councillor McCammon, and we have no apologies, so it's just requesting your approval for remote participation. Thank you.
Which I approve of, thank you. Members, we're on to item number 2, declarations of interest. Do any members have any declarations they'd like to make? I'm seeing no hands up in the chat, so moving on, members. I have no minutes in front of me, so I'm on to this one. We're on to item 3, which is Licensing Scotland Act 2005, the Act, Section 84A, conduct inconsistent with the licensing objectives, personal licence holder Robert James Maxwell, report by the clerk to the board. Clerk, could you go through this, please?
Thank you, convener. Item number 3 is an allegation that Mr. Robert James Maxwell, personal licence holder, has acted in a manner that's inconsistent with the licensing objectives in terms of Section 84A of the Licensing Scotland Act 2005. I would just like to ensure, convener, that Mr. Robert James Maxwell is here this morning and that he can hear me clearly. Mr. Maxwell, can you confirm that that is you and that you can hear me, please? Thank you.
Yes, thank you.
Thank you. And also we have Anna Boyd from Police Scotland. Anna Boyd, can you confirm that you can hear me okay, please?
Good morning. Yes, I can hear you clearly. Thank you.
Thank you. So members, because the board has received a Section 84A report from the Chief Constable, and you must in law hold a hearing. On the 18th of July 2024, the Chief Constable, in terms of his power under Section 84A of the Act, submitted to the board a report alleging that Robert Maxwell, the holder of a personal licence, has acted in a manner that's inconsistent with the licensing objectives of preventing crime and disorder, securing public safety and preventing public nuisance. Remember, that report from the police is detailed at Appendix 1. In terms of procedure, the police letter and the notice of hearing has been sent to the licence holder, and you will recall that a personal licence issued by the board authorises the licence holder to supervise and authorise the sale of alcohol. Moving to paragraph 3 of the report, at the hearing, the board may, after giving the licence holder concerned and such other persons as they consider appropriate, an opportunity to be heard. And if you're satisfied that it's necessary to do so for the purposes of any of the licensing objectives, you could make an order revoking the licence, suspending it for a maximum 6-month period, or endorsing the licence. It's also open to the board today to take no action. If, however, you're of the view that the licence holder is not a fit and proper person to be the holder of a licence, then the law directs you that you must indeed revoke that licence. Just checking from the outset, convener, the licence holder did submit evidence that came in at the 11th hour yesterday. The licence holder submitted to the board yesterday a letter from a bartender and 4 till receipts. Now, these were forwarded, I understand, to the police yesterday, as well as to yourselves. And as a preliminary point, convener, you may wish to ask the police whether they have had time to digest and consider the terms of that evidence that's been submitted by Mr. Maxwell, and whether the police are indeed happy to proceed with today's hearing, given that that evidence was submitted at the late hour, or whether alternatively, in fairness to the police, they would wish the hearing to be deferred to a future date to consider that evidence, just as a preliminary point, convener.
Thanks, Karen. I'm going to start by asking if the elected members on the committee are happy to agree that they've digested that information first before we move on and ask the police. Are the elected members happy to go forward? Councillor Hill?
Yeah, I've had time to digest it. I'm happy to go forward, thanks.
Thank you, Councillor Hill. Councillor McCarman?
Yes, same. Thanks, convener.
Thank you very much. And now, Anna, are you happy to agree that you've digested the further information came from the applicant?
Thank you. Yes, I'm happy. I've viewed that just in the last hour. The only point I would make is that I think there's maybe a slight error in one of the submissions with the date of the receipts. Just by my calculations and with speaking with the council this morning, I think the dates may not relate to one of the dates in question.
Thanks for that, Anna. So, members, we're going to move on to the next part of this process, which is we're going to hear from the police. So, Anna, would you like to give your presentation, please?
Thank you, convener. As stated, this application from Police Scotland relates to Section 84 of the Licensing Scotland Act and consists of a report that Robert James Maxwell has acted in a manner that is inconsistent with the licensing objectives, namely preventing crime and disorder, securing public safety and preventing public nuisance. Mr. Maxwell is the holder of a personal licence issued by Wigtown Board on the 7th of February 2023. This stands for 10 years and expires on the 6th of February 2033. At the time of the instance which I'm about to discuss, he is the premise licence holder and the designated premise manager for the Star Inn premise located in Newton Stewart. This premise is a public house which is within Dashwood Square. It is in an area of both the commercial and residential properties of the town of Newton Stewart. The operating facility plan for the premise does not provide accommodation, restaurant facilities or bar meals. And specifically for these two incidents, the core on-sales alcohol licensing times on a Friday are between 11 AM in the morning and midnight as stated within the STAR's premise licence. The first instance that I'd like to bring to your attention has occurred in the early hours of Saturday, the 15th of June, which would be covered by the operating hours of Saturday being 11 AM to midnight, or opening hours of Friday, which are again 11 AM to midnight. The incident occurred at 20 to 1 in the morning of Saturday, the 15th of June, whereby Police Scotland officers were on mobile patrol and have noted the Star Inn to still have patrons within. Those officers were of the belief that the licence of the premise was until midnight on a Thursday, Friday and Saturday as stated, and have attended the premise to carry out a check. At that time, they've noted about 20 patrons within and noted many to still be drinking alcohol at the bar and tables. It's recorded that some had full pints of lager and some were drinking from what appeared to be Budweiser bottles. There also was karaoke ongoing within the premise. Mr. Maxwell, the licensed premise holder, was standing at the front door of the premise at that time. He was asked by officers if he had an extended licence for that date, and he stated he did not, but advised the officers that his premise licence ran until midnight. Officers left the premise at that time to conduct inquiries in relation to the terminal hour to check their knowledge, and it was later confirmed by them that the premise core hours finished at midnight. CCTV footage was obtained from the surrounding area, which showed persons leaving the premise between 00:46 and 00:53 hours on the morning of Saturday, the 15th of June. On the 4th of July, the officers contacted Mr. Maxwell on his mobile phone to inform him that police required to speak to him. At that time, Mr. Maxwell responded that he would be requesting his solicitor's attendance to speak with police, and furthermore that the police should no longer contact him about any incidents and he would no longer aid the police with any inquiry going forward. Due to the observations the officers had made on the morning of the 15th of June, on the 5th of July, Mr. Maxwell was formally cautioned and charged under the Licensing Scotland Act, Section 63, for allowing the consumption of alcohol within his licensed premise out with his the core hours. Mr. Maxwell replied to the charge, "We weren't serving alcohol at that time, and I was in the central by 00:35 hours. It was just bar staff decorating." A second incident has occurred on Saturday, the 29th of June, 2024. Similarly, at about 20 to 1 in the morning on Saturday, the 29th of June, officers from Police Scotland have been on mobile patrol within Dashwood Square and noted the Star Inn still to have many patrons within. Their observations were there was about 15 patrons within the premise, many drinking what appeared to be alcohol at the bar and tables. When they approached and asked the licence holder, Robert Maxwell, about the incident, he stated his licence again was until midnight. At 1:45, police officers asked Mr. Maxwell to remove the patrons from within the bar, which he declined to do so and told the police to do it themselves. At this point, officers report that he was hostile towards them. The police thereafter removed the patrons from within the premise with some minor, what I have described as verbal resistance to them. During this time, Mr. Maxwell made no effort to aid the police, instead asked them to leave and stated it was a private family function and he would take up the issues presented with the licensing board. Due to the officers' observations on that night of the consumption of alcohol after the terminal hour, Mr. Maxwell was formally cautioned and charged under Section 63 for allowing the consumption of alcohol on his premise out with the licensed core hours. Having completed the necessary training to apply for and be granted a personal licence, Mr. Maxwell would and should be well aware of his requirements to adhere to the licensing objectives and cooperate with police inquiry. As both the premise licence holder and the designated premise manager, it's Mr. Maxwell's responsibility to ensure that he is conversant with the information within his operating plan. It's Police Scotland's opinion that by being found within the premise in open contravention of the licensing hours not once but twice, Mr. Maxwell has shown a disregard for the licensing laws. His refusal to help officers clear the premise when asked to do so, and thereafter his refusal to cooperate with Police Scotland inquiries, falls short of the expected behaviour of a licence holder in a position of authority and a duty of care for his patrons. It is in light of the above two incidents, it's considered that Mr. Maxwell does not support the licensing objectives of preventing crime and disorder, securing public safety and preventing public nuisance, and therefore Police Scotland wish the board to consider all options open to them under the Licensing Scotland Act in relation to his personal licence status. Thank you.
Thanks, Anna. Members, were there questions for the police? I'll kick us off because I'm not seeing any hands coming up. Oh, Councillor Hagman, you can go first. I'll defer.
Thanks, convener. No, thanks for the report there, Anna. I guess my question is in terms of the evidence that the police have gathered, in terms you've referenced CCTV, that hasn't been submitted as evidence to the board. Can I ask why not? And my second question is, you've referenced that there has been cautions and charges made, but has this been through the judicial system? Has there been a conviction at this point, or are you still awaiting that outcome for that?
That's okay, Anna.
Thank you. To be honest, I can probably sum those two questions up in one answer. The report has been submitted to the Procurator Fiscal, and I am advised that there is a court date scheduled very, very shortly. and that is the reason why the CCTV evidence has not been submitted. This case is self-subjudical, so without the express authority of the Crown Office, we cannot release the CCTV footage to this panel at this time.
Thanks for that, Adam. Any other members with questions? Or Katie, did that answer your question?
Yeah, no, it did. I guess, yeah, no, it's fine. Thank you.
Councillor Hill?
Yeah, I'm just a wee bit confused as why this was pulled before the licensing board so quickly. If it didn't have all the evidence to prove, should it surely not have waited until it had been to court and we could have the CCT evidence if it's prominent within this case? Thanks.
Thanks for that, Councillor. Anne, have you got an answer for that or a comeback, or is it just the same as the answer you gave to Katie?
In relation to our submission, Police Scotland will always submit information that is available to them at the earliest opportunity if we feel there's been any contravention of the licensing boards. I know there can be challenges when it's not been through the courts. However, if we hold information that we feel is relevant to the board, we will submit it at the earliest opportunity.
That's what I am. So I'm going to ask a couple of questions now. On page 7 of our report, it's incident number 2, Saturday the 29th of June 2024. To the end of the first paragraph of that, you say that Mr. Maxwell adopted a hostile and combative demeanour with police. Now, in your briefing that you gave us there, you said hostile but not combative. Can I ask what you mean by combative? Because that to me sounds like it's going to be throwing punches.
I wasn't personally there, so I can't express what exactly combative would mean in relation to the officers what they're there. I've likely not said that, as I've just been reading off my notes and not specifically read the letter word for word. What I would say was I have got no evidence or suggestion that there has been any physical or altercations at any point between Mr. Maxwell and the police officers, and they have used words to describe the environment at that time. But had there been anything like that, I would be fully aware, and I'm not aware of anything that would constitute anything physical occurring. To my understanding, it's been verbal discussions between the officers.
Thanks for that. It's just because it is quite a physical word. It appears in the document that's been given to us. So I've got more questions. Based on the free licensing objectives that you've stated, preventing crime and disorder, we don't have we have a charge, but we don't have a conviction yet. How can you link that in? Securing public safety. How was public safety imperiled by people staying over the licensed over the licensed hour? And again, with preventing public nuisance, how was public nuisance created by this bar being open after its hours?
Okay, I'll take those one at a time. I'll go with the most recent one there, the public nuisance. Police Scotland's opinion would be that the core licensing hours are there to protect the general area around the licensing premise, and it has been decreed that the licensed premise closes or is closed to patrons from midnight. We've obviously had people leaving the bar later. That can naturally bring noise disruption in relation to public nuisance in the surrounding area. The second point in relation to public safety, I would go with a very similar stance in that we have had people consuming alcohol out with what the board has decreed to be the licensed hours of the premise. Again, the surrounding area and both those patrons that have been within the bar consuming on premise after the licence hour, both the board, Police Scotland and the licensee have got a duty of care in relation to their safety, and we believe consuming alcohol out with the hours would potentially put that at risk. Preventing crime and disorder, there has not been any reported incidents of crime and disorder after the incidents at this time. So I'm more than willing to accept that that licence objective is weaker in relation to the association that we can make there. However, I would again just reiterate that the core hours have been set down by the board in line with all the licensing objectives, and anybody breaching the core hours, I believe, is not acting in a manner consistent with any of the licensing objectives within the Licensing Scotland Act 2005.
Thanks for that, Al. That was a good response. Just ask another question on that. Is what is the latest licence in Newton Stewart at the moment? Or is that flanking you a little bit? Sorry.
A wee bit, but I can have a wee look unless Julia can dive in and help me with that one. But off the top of my head, I don't know, to be honest.
I'm happy to wait for an answer on that one. I'm not going to put you under pressure for that. But if you could get that, Julia, I don't know. But I've got a question from Chrissy at the minute, Councillor Hill.
I think it's 2 o'clock and it's a central bar.
No.
Thanks for that, Councillor Hill. Can you confirm that, Julia?
So 1 o'clock on a Friday evening, 2 o'clock on a Saturday. Off the top of my head, but I'm pretty sure that's the case.
Thanks for that, Julia. I'm just trying to link that in with the public nuisance aspect that was brought in here, and I guess you know where I'm going with that. Councillor Hill, did I see your hand go up before you wanted to come in and answer a question?
No, that's absolutely fine, thanks.
So members, do we have any more questions for the police officers? Councillor Ingalls?
Sorry, convener, it's no actually for the police officer. I'll come back in.
Thanks for that, Councillor Ingalls. So members, we've heard from the police, we've questioned the police, and now we're moving on to our licence holder, which is Mr. Maxwell. Mr. Maxwell, would you like to give us a presentation, please?
Yep. Referring to the 14th of June, it was bar staff that was in, and 2 of our friends. We were decorating the pub for my wife's 40th birthday party on the Saturday night. There was nobody sold alcohol after time. I asked Mr. Clockey if he'd give me a handshake. The pool table before the band came in on the Saturday night, so we were decorating with an arch. The police did not come into my premises at all on the Friday evening. They sat outside in the police van, and I went outside to speak to them. On my understanding, I've got a 12 o'clock licence, but I actually thought the drinking up time was half an hour till 12:30, so I've made a mistake there with the 15 minutes. I always give the elderly people a lift home any night they're in, because we cannot get taxis in the town. So I'll allow them to stay in while they tidy up, cash up, and then we all go out the back door. The 29th, PC McEwen came up to the pub. I spoke to him outside. My front door was actually pushed over, shut. Again, it was Billy and Ann Clucky, Billy McGuffey, Kate McGuffey, my bar staff, Fiona, my wife and my daughter that was in the pub. The karaoke was not on that Saturday evening at all. When the police came in, Mr. McGuffey was singing, which he always does. When the police entered my premises on the 29th, Miss Clockey, that was working behind the bar, was beside the jukebox, at the table beside the jukebox, clearing glasses off the tables. Where the police came in and stood, all my glasses were on the bar. My glass washer was right beside the bar. There was nobody being served alcohol or drinking alcohol when the police came in. When I was talking to the police outside, a guy called Johnny, who came from the Black Horse, walked into my premises thinking we were still open. I went in The police actually tried to shout him and tell him the pub was shut, but he carried on walking in. So I went in the door and said we're closed. That gentleman left. PC McEwen was offered to go behind the bar and have a look in the till to show that everything was cashed up, which he refused. He said no, point blank no. He says, can you get everybody out? I says, the ones that are left, I'm giving a lift home. He said that he would throw them out. I said, why would you throw them out in the street when there's no taxis, when I'm giving them a lift home anyway? He just told everybody to get out of the pub. I shut the door and I went round, drove round and picked them up. That was the end of it. The police, when they came to see me on the 5th of July, I think it was, I asked if this was a criminal charge and they said no. They had not formally charged me. They told me they were sending a report to the licensing board. That's why I gave that reply. I was not serving alcohol. But they hadn't told me that I was cautioned and charged. I've been having a few problems with the police over a number of weeks prior to this, which is getting dealt with. And ever since I've pulled I've never really pulled the policeman. I asked him why he was messaging my daughter on Snapchat. Ever since that, the police have never been away from my pub. They just seem to be trying to pick fault every week with me, but they never seem to go in any other pub, which I've seen with my own eyes. That's
Thanks
all
for
I've
that,
got to say.
Thanks for that, Mr. Maxwell. Mr. Maxwell, I'll be handing over to members for questions. I see Councillor McCarman has a question.
Yeah, thanks for that, Mr. Maxwell. It's just a wee bit of clarity for me, please. When you are saying that there was no alcohol being sold, can you just confirm there was no consumption either? Specifically on the night of when the police quoted, and I quote, they would throw the patrons out. So can you just confirm that there was no alcohol being consumed either, and as well as no sale, please? Thanks.
Councillor McCallum, there was no alcohol being drank on my premises on that evening. All the glasses, the way my bar is, it's like a U shape. So we had some people sitting at the top. We had Billy and Ann Cookie was sitting like directly in front of us. Where all the glasses sit on my bar, my glass washer is right there. So once the tables have been cleared, we have to pile them there to put them through the glass washer. There was nobody consuming alcohol on the 29th of June.
Okay,
when the police came in. And my front door was actually shut and they pushed it open.
Thanks for that, Mr. Maxwell. Mr. Maxwell, I don't see any other hands up, but I'm going to ask you a question. Within the police report, as I asked Anna, incident number 2, Saturday the 29th of June, and at the end of that first paragraph, you're accused of adopting a hostile and combative demeanour. Could you shed some light on that, or?
Yes, I can. Yeah. PC McEwen asked me to get everybody to leave, and I asked the question of why I would ask the people to leave and go out on the street when I'm giving them a lift home. He says, I want you to put them out. And I says, I'm not putting them out because I'm not going to chuck them onto the street. There is no taxis available in Newton Stewart on a Saturday night or a Friday night, any night really after a certain time. I was not prepared to chuck people out on the street, especially older people. We don't get any young people in the pubs. Can I clarify that? In our pub, we are like middle-aged to elderly people, which we are quite happy with. We don't get any trouble. We don't get anything. Any weeks, the police are never called to come to our pub for trouble. And I just wasn't prepared to throw elderly people out in the street. I just refused. I only refused to throw them out in the street. I wasn't being hostile. I just refused. So he said he would do it.
Thanks for that, Mr. Maxwell, because there is that imagery in the report that makes you think that you were becoming maybe physical and perhaps physically intimidating and combative, but you've
Never.
said that that's absolutely not the case. Thank you
Never.
for that. So Mr. Maxwell, after the first police visit, they would have told you what your licensing hours were.
They did.
Or,
They said
or
it
was
meant
that
at
under-
midnight. Sorry?
No, sorry. Aye, so they would have told you what your licensing hours were. So you would have known what your license hours were for the next time.
I knew what my license hours were, but I didn't know. I thought it was half an hour drink up time. The police never once mentioned to me that my license time was midnight and everyone had to be out by 12:15. They've never once told me that. But I always thought it was half an hour drink up time, so I made a mistake there with the 15 minutes. So
That's what I was about. So Mr. Matt, just one on top of that. How long did you manage this bar for?
2 years.
2 years, right? And this is the first time that we've had any incidents.
Yes.
Thanks for that.
To
Councillor
do
Inglis,
with my pub, sorry.
no problem. Councillor Inglis, I see you've put up to speak. Councillor Inglis?
Sorry, can you hear me?
Yeah,
you sort of preempted me there, convener. My question was revolving, since this is all about hours, it was revolving around the hours and Mr. Maxwell's understanding of what his bar hours were and what the drinking up time was. Following last orders at midnight, you can sell alcohol up to midnight and then there's a drinking up time and one thing or another. So it's really the difference between what that allowance is and the time between 12:30 and 1 o'clock that's really causing a bit of an issue here. But you've crossed that one, so I'm quite happy with that answer, convener.
That's for that, Councillor Inglis. Councillor Hill?
Yeah, hi, thanks, convener. So the drinking up time is 15 minutes. Is there a time that people have to vacate the premises by law, please?
15 minutes after the drinking, well, within the 15 minutes drink up period, they have to be out at the end of that, Councillor Hill. So 15 minutes after the terminal hour. But I'll bring in Caroline Trainer, our licensed solicitor to confirm.
Thanks.
Yeah, thank you, members. So the terminal hour in this instance is 12 p.m. and the drinking up time is 15 minutes thereafter. And the allegation in terms of breach of section 63 of the Act is allowing consumption of alcohol out with the licensed hours, and you have that 15 minutes. The law does not direct that everybody requires to be out of the premises immediately following that 15 minutes drink up time, but it's certainly good practice to ensure that everything is cleared out. The offence is allowing the consumption of alcohol out with licensed hours unless it's within that 15 minutes drinking up time. But there's no specific direction that everybody must vacate the premises, but it would be good practice to ensure that everybody has vacated those premises following that 12:15 p.m. And in terms of the policy statement, the terminal hour for Newton Stewart is 1 a.m. But in this instance, Mr. Maxwell does not have that full policy hour. Just to clarify, thank you.
Thank you for that, Caroline. Councillor Hill, would you like to come back on that?
Yeah, no, I just wanted clarification on that because I was unsure. I just wanted to have it confirmed that it is good practice to have them out. The consumption was the 15 minutes, but actually getting them out of the pub is good practice to have them out quickly, but not legally binding by law. Thanks.
Thanks for that, Councillor Hill. Councillor McCarman?
Yeah, thanks, convener. If I could just ask, am I able to ask Constable Boyd a question, or is it just purely for?
If we can stick to the applicant for the moment.
Okay.
And
I'll come back in there.
I'll come back, not a problem. Do we have any more questions for the applicant? Well, not the applicant, sorry, the licence holder, Mr. Maxwell, I think you've got off. Oh, Councillor Inglis.
Sorry, just a quick one for Mr. Maxwell. In the 2 years that he's been there, have you had any previous issues with the police in the Star Inn?
Councillor Inglis, the only time I've had dealings with the police is when I've called the police to come up when I've had some issues in the pub. We run a very strict place in the Star Inn. The police have come in and swabbed my toilets and never found a single thing ever with cocaine or anything. We are very thorough. I will ban people. I even banned a pub owner for 6 months for taking drugs in my pub. That was only last year. We run a very strict place. The police have never come in unless I phoned them to come up and deal with an issue for me, which they've always done.
Okay, thanks for that, Mr.
Thank
Maxwell.
you. Thank you.
Thanks for that, Mr. Maxwell. I think that's the last of the questions to you. I'm going to allow Councillor McCalman back in for a question to the police. If you're there, Anna.
Yeah. Yeah, so it was just the allegation there of Mr. Maxwell claiming that the police threatened to throw patrons out. Can we get confirmation on that, please? And for reasons why, if there's a difference between drinking up and taking their drinks off them and throwing patrons out. So if we could just get clarification on that piece of, or claim, sorry, just so that I can get it right in my head. Thanks.
No problem. So the information I have is that the officers said that asked Mr. Maxwell to remove the patrons from his premise because they had seen them consuming alcohol out with the core hours and after the 15 minutes grace period, which would put an offence under section 63 of allowing consumption of alcohol out with the core hours, including that 15 minutes period. The information I have is that Mr. Maxwell refused to ask his patrons to leave, so the officers have asked them to leave to clear the premise as they saw a clear breach of the consumption of alcohol out with the core hours of the premise.
Sorry, convener, can I just come back just quickly? Just
Absolutely.
it's purely my understanding of the law. So, so Caroline's just stated there that there's no legal obligation for the patrons to be removed from the premises. But Caroline, if you could come in and correct me here, but if they are consuming alcohol out with the licensed hours, are they permitted to remove the patrons, please?
Caroline Traynor, licensed and standards officer.
Thank you, convener. So the offence is allowing consumption of alcohol out with your core hours. So the terminal hour is 12, but the law allows a 15-minute drinking up time to 12:15. So the police position is, sorry, there's background music.
Sorry, Caroline.
Not at all. I can,
Abby Byrne, the text, your mic's on.
I'm having difficulty. Thank you. That's much better. Thank you so much. So the position of the police, as I understand it, councillor, is that they're alleging that Mr. Maxwell allowed that consumption of alcohol out with the 15 minutes drinking up time as well, and perhaps Anna Boyd can confirm that is the case. I can see Anna Boyd, I think, nodding in agreement there. So you're permitted to have that 15 minutes drinking up time. Thereafter, you must stop consuming alcohol, else it's a statutory offence. And the police position, as I understand it, is that the consumption of alcohol took place out with the 15-minute drinking up time. And if that is the case, and there's evidence to suggest that is the case, then an offence has been committed under section 63 of the 2005 Act. And I think here is whether there's evidence to prove that there was consumption of alcohol out with that 15-minute drinking up time. But in terms of there being a legal obligation to clear everybody out of the premises at that time, there's nothing in law, but it would be good practice. But to focus in mind, the issue here is there evidence to suggest that there was consumption of alcohol out with after 12:15 midnight? And my understanding is that the police position is that there is a breach of section 63 because there was consumption in their view of alcohol after that 15-minute drinking up time. Does that assist?
Yeah, absolutely. Thank you.
Thanks for that, Caroline. Quite a bit of a tongue twister, that one. Members, do we have any other questions for anyone before I move on to the summing up? I'm seeing no hands. So can I invite Anna Boyd from the Police Scotland to sum up, please?
Thank you, Chair. As previously stated, Police Scotland have brought this application in relation to Mr. Maxwell, as we believe he's acted out with the principles of the Licensing Scotland Act. There has been 2 incidents reported today whereby police officers have observed the consumption of alcohol out with the core hours within the Star Inn whilst Mr Maxwell was the premise licence holder, the designated premise manager, and individually a personal licence holder, which is in what this application is in respect of. Police Scotland believe that as a personal licence holder, he has the responsibility to understand and comply with all the regulations within the Licensing Scotland Act, and by allowing the consumption of alcohol out with the hours of his licence, he has breached these conditions, and therefore ask the board to consider carefully this application submitted by Police Scotland.
Thanks for that, Anna. Mr. Maxwell, would you like some time to sum up your position, please?
Yep. Can I just say that no alcohol was sold after midnight on any of the two occasions? I would not do that. The bar staff I have are very strict. I wasn't even working any of the two nights, but I always come down to lock up, take people home that's needing a lift home because we can't get taxis. But I can assure you, I have plenty of witnesses that will verify that there was no alcohol served after midnight, as I've got the till receipts as well. And I will produce any till receipts they want. Thank you very much.
Thank you for that, Mr. Maxwell. Well, members, we're now in session. Do we have any suggestions, members? I'm not seeing any hands going up straight away, but I have a suggestion. Oh, Councillor Hagman.
Thanks, convener. Yeah, so for me, this is really challenging because there's conflicting evidence being provided both by the police and both by Mr. Maxwell. And I think the fact that we don't have the CCTV evidence is putting us at a disadvantage. And also the fact that the outcome of the report to the Procurator Fiscal is not as yet known, I think also puts us at a disadvantage. So I would just maybe like to, perhaps it was a question, but
Sorry,
maybe
Kate, Mr. Maxwell, we can hear you over Councillor Hagman.
Sorry.
If you would mind, please. Thank you.
Sorry, thank you.
No, that's fine. Thank you. I think for me, it would be really useful to see that evidence. If we were to request that evidence, is that likely to be able to be produced at all in order for us to actually have the fullest of information before we determine an outcome here?
Thanks for that, Councillor Hagman. Do we have any other? Oh, the hands are flying in. Councillor McCarman.
Yeah, similar comments, convener. I feel a wee bit uncomfortable making a decision with the lack of evidence here. So, yeah, that's my input.
Thanks for that. Councillor Ingles.
Goodness, I'm slow on this mic today. Sorry, convener. I'd like to take this into private session if we can, just for 10 minutes.
That's not Councillor Ingles. I'm going to go to Councillor Hill and then we'll look to go to private session.
Thanks, convener. Just with the points Councillor Hagman and Councillor McCammon made there, the CCTV evidence is going to show potentially the police are saying when patrons left the pub, and that isn't the case because there isn't a law to what time they leave the pub. The case here is the consumption of alcohol, which is inside the pub. So the CCTV evidence really isn't relevant in this, is it? Or is that me being, I don't know, confused?
I would suggest that the evidence that we were looking for would be to prove if there was A, sale of alcohol after the terminal hour, and B, drinking of alcohol after the drinking up period, which is 15 minutes. I would suggest that's what the CCTV evidence would be looking for. But I see Caroline's got her hand up. I'll bring in our solicitor, Caroline.
Thank you, convener. It was just to possibly assist here in relation to the CCTV. So the police have advised that CCTV has been forwarded to the Procurator Fiscal. So I think at this moment in time it may be just a wee bit premature to, given that you've not had sight of that CCTV, it may be a wee bit premature to kind of speculate as to what its contents will be. The police have alleged that Mr. Maxwell has breached Section 63 of the 2005 Act, consumption of alcohol out with licensed hours. the police have submitted CCTV to the Procurator Fiscal in support of their case, and to support, I think it would be wise just to see if you can, that the content of that CCTV would clearly require to show consumption of alcohol within the premises, but it's all perhaps a wee bit speculative at the moment.
Thanks for that, Caroline. Councillor Hill, did that answer the question?
Yeah, it did. I was under the impression that the CCTV showed patrons leaving the premises. But can I just ask Caroline, section 63 of the Licensing Law Act, it actually says at point 133, because I've just looked up the period of 15 or 30 minutes. Does that depend on what the Pacific license says for drinking up time?
It's 15 minutes.
It's 15 minutes, counts in relation to, if there's no food, it's 15 minutes drinking up time. So in this case, it would be until 12:15, and the police are alleging that there has been consumption of alcohol out with that after 12:15, out with that 15 minutes drinking up time.
Okay, thank you. Just I was looking up the legislation there and I was a bit confused when it said the period of 15 to 30 minutes, so it must be different on different licenses. That's fine, thank you.
Thanks for that, Councillor. Councillor Hagman, your hand flicked up for a moment just after Councillor Hill's. Were you wanting to come in?
It's fine, convener. Thank you.
Right, no problem. Thank you. Councillor McGowan.
Yeah, it's just a quick question again for the licensing holder. Do you have CCTV on your premises?
I do, yes, but
inside.
Only the police have never asked me for CCTV footage.
Okay.
They've never asked me for it, and it goes over after 28 days, so it covers over. I tried to look for it yesterday, but it was covered over.
Okay.
The police have never asked me for CCTV. The only CCTV they've got is Macmillan Hall for people coming out on my premises when they threw them out. He told me that himself.
Thanks for that, Ms. Maxwell. So, Caroline?
Thank you, convener. It was just to assist to advise that in terms of the current premises licence, as far as I see, there is no requirement for the premises licence holder to have CCTV in relation to the premises. It's not been added to the licence, the one that's in front of me, certainly, as far as I can see. So if there is CCTV in relation to the premises, then my understanding is that that would be a voluntary measure on part of the licence holder.
Thanks for that, Caroline. So, members, at the minute, I've got a proposal by Councillor Inglis, to go into private session. Do the members feel we need a private session?
Yeah, happy with that.
The members will go into private session. Yep. We'll go into our separate breakout meeting, and we'll reconvene hopefully in 10-15 minutes. Thank you. all back, barring Councillor Hagman. So Councillor Hagman has had to leave, unfortunately, and she will no longer be determining this application, not this application, this hearing. But we are still core it. We still have Councillor Ingalls, Councillor Hill, Councillor McCarman, Councillor Dashborough, and myself as the convener. So members have had a private deliberation to ask questions of our legal aids, and members, I will throw open to you. Councillor Hill.
Is Councillor Dashborough back? Just I can't see him on the screen, just to double check.
Yeah, he's still there.
Yeah.
He's there, yeah.
So for me, I don't feel that there's enough evidence brought forward by the police for us to proceed with this. So for me, it will be take no action. Thank you.
Thanks for that, Councillor Hill. Councillor Ingalls.
Thanks, convener. I'll give you my view of this. The licensing hours are there for a reason, and the one evidential point within this whole deliberation is that the hours were exceeded by the Mr. Maxwell, and he's accepted that. You know, the fact of the matter is patrons should be out of the premises by 12:15 or thereabouts, and that's good practice. However, I'll also take on board the fact that the bar doesn't seem to have had any major issues over the 2 years since Mr. Maxwell took over. You know, this has happened over a 2-week period. So my view would be that Mr. Maxwell has to acknowledge the fact that the licensing hours are there for a reason. He has to stick by them. And I would move that we write a letter of warning to Mr. Maxwell, and that'll go on record.
That's for that, Councillor Ingalls. Councillor McCarman.
Yeah, I would second Councillor Ingalls there. And as Councillor Hill mentioned, that there just is not enough evidence to back up the case at this point. So yeah, I think a warning letter needs to be sent so that Mr. Maxwell doesn't appear in front of us again. Thanks.
That's right, Councillor McCarman. Councillor Dashborough, have you got any views?
No, I'm happy to go with the consensus, convener.
Well, members, I'm going to throw a spanner in the works and second Councillor Hill, but on the caveat that I don't feel like we have the evidence in front of us today. I don't think we've got the evidence to prove that you've not held up the licence objectives, which is preventing crime and disorder. We have no conviction. Securing public safety, I don't think public safety has been imperilled. If not, your duty of care, if you're correct, Mr. Maxwell, that you're giving the public, your customers, lifts home when there's no taxis, might be your duty of care is actually, it's a better place. Preventing public nuisance, there's been no report of public nuisance, and the terminal hour for the rest of the units is 1 AM, sorry, and none of our hours that we've dealt with today go out with that, so I don't see how the public nuisance aspect comes into this. So I'm going to suggest, and back Chrissy, Councillor Hill, that we take no action, but I would put it on the caveat that you engage with licensing officers and the LSO just to firm up your conduct at the end of the night to make sure that glasses are collected and there's no glasses out after after 15 minutes past your terminal hour, and that if you do have people waiting, that there's a way that we can prevent them from causing any issue in the future, so that they're waiting in a place that's safe and away from alcohol, and that's clear. I think that's fair. So members, we've got 2 suggestions on the floor. Caroline, you've put your hand up.
Thank you, convener. Apologies for just interjecting, just so that I've got absolute clarity here in relation to any warning letter, if that was given to remind Mr. Maxwell of his terminal hour, the law in relation to drinking up time, and suggested good conduct. That warning letter would not have any legal basis. That would just be a persuasive letter that would be on his record. And my understanding is that there is a motion from Councillor Inglis to issue that warning letter that has no legal basis, and that is seconded by Councillor McCammon. And then there's an amendment by yourself, beg your pardon, there's an amendment put forward by Councillor Hill that no action be taken on the basis that there is no evidence, and that is seconded by yourself, convener. Just for clarity, is my understanding correct?
But that is correct, but I don't know if we can put the caveat that I would like Mr. Maxwell to engage with the LSOs in due course to solve the issue of that he has no taxis, and that maybe putting elderly people onto the street isn't the best interest of the customer and his duty of care. I don't know if that could be worded in there, Caroline, but if I can't put that officially down, he's heard what I've had to say anyway.
Just for clarity, convener, so again, there's no legal basis that you cannot compel, as you're aware, Mr. Maxwell, to undertake that conduct. So is it the case that you would like a letter to be sent to Mr. Maxwell advising that you would like him to engage with LSOs in due course in relation to his obligations? And is that the amendment that's proposed by Councillor Hill to take no action? Does that include that suggested letter being, just for clarity, being sent to Mr. Maxwell? And as you're aware, there's no legal basis for that letter. Just for clarity, is the motion from Councillor Hill including that letter to be sent to Mr. Maxwell?
So Councillor Hill and then Councillor McConnell.
I think Mr. Maxwell's heard it, and I think because the letter holds no legal forum in it, I think the LSO is in the office with Mr. Maxwell, or somebody from the licensing board will be informed of the outcome. I think it's just advice to Mr. Maxwell that if people are waiting for taxis, they're not sat at the bar in front of glasses, that could be then construed by the police and bringing back here. But I don't really think that a letter is going to upstand anything, because it's not legally binding. I think we've been quite firm with Mr. Maxwell. I think he knows that, what he needs to do. And I agree with Councillor Giusti that, he is a duty of care. Taking people home and putting them out on the street could then cause a nuisance, which would be one of the licensing objectives, which we haven't got evidence for today. So I'm quite happy for no further action to be taken. Thanks.
On the money there of what I was thinking, Councillor McCarman, I see you want to come back in.
Yeah, correct me if I'm wrong, but I think everybody's saying the same thing here. I'm not entirely sure why we're having a debate about it. I think it's good practice to always have things in writing, particularly, and I'm not saying there's going to be future cases or anything, but I think for reference, it's just how I work. So I'm going to stick with, if David still put his motion forward, I'm going to still stick with that, because I think it's good practice to have everything in writing.
Thanks for that, Councillor McCarman. Councillor Inglis, do you have to keep your motion?
Absolutely. I think it's important that we at least record the fact that we view this as a serious breach of licensing protocol within licensed premises, and I think Mr. Maxwell has to realise that that's the way we view this. So I'm sorry, but taking no action is not really the way I would go on this. I think there needs to be action, albeit something that's not maybe legally binding, but it needs to be recorded. And I would agree with Councillor McCammon on that one. Thank you.
Thanks for that, Councillor Inglis. Councillor Dashper?
Yeah, I don't think I've signified support for the motion or amendment yet. No. So can I just have them read back to me for clarity?
Not a problem. Carla, have you got them written down, or would you like me to go over the motion?
I'll state my understanding that the motion from Councillor Inglis is that a warning letter be given, reminding the licence holder of his hours, his obligations, the drinking up time. Councillor Inglis has said that viewing the serious breach of licence protocol, it may be that so there's complete transparency there. What is actually meant by that? Is that in relation to removing patrons from the premises following drinking up time? and Councillor McCammon has actually seconded that motion for that warning letter to be given, bearing in mind there is no legal basis to that warning letter, but it's, as I understand it, it's a reflection of how serious the board is taking matters today. And on the other hand, the amendment from Councillor Hill is that no action be taken with no letter sent, because her view is that there is no evidence before the board today to make a determination that any of the licensing objectives have been breached, and the convener has also seconded that amendment that no action be taken.
There we go,
Okay,
Councillor
thank you.
Dashford.
I'd like to vote for the motion, please.
No problem. So we'll move on to the roll call then, Caroline. Unless Councillor McCammon, is that a legacy hand? I don't think you took your hand down.
Sorry, convener.
No problem. So, Caroline, if we can go to the vote, please.
Thank you, convener. So there is a motion put forth by Councillor Ingalls that a warning letter be given to the licence holder, just to remind him of his obligations, the hours in relation to his terminal hour, drinking up time, viewing a serious breach of licence protocol whereby patrons should be removed from the premises following the conclusion of the drinking up time. This motion has been seconded by Councillor McCannon. On the other hand, there is an amendment based on the fact that there is, based on the view that there is no evidence to support that there has been any breach of the licensing objectives, that from Councillor Hill, no action be taken, and this is seconded by the convener, that no action be taken. So going through roll call, Councillor Ingalls. There's a motion seconded by Councillor McCammon. The amendment forwarded by Councillor Hill, seconded by the convener. So Councillor Dashford.
Motion, please.
So Councillor Dashford has voted for the motion, which means the motion carries, and that the board today shall issue a warning letter that has no legal basis, but shall be reminding the licence holder of his obligations, the terminal hours, the law surrounding drinking up time, and suggesting that there's a serious view in relation to breach of licence and protocols where patrons ought to be removed from the premises following conclusion of the drinking up time. So the board has decided that that warning letter shall be issued by the licensing on the team, but there is no legal basis to that warning letter. Thank you.
Thanks for that, Caroline. Members, moving on to item number 4, and it is Licence Scotland Act 2005, the Act, Premises Licence Review, Section 36, Premises The Star Inn, number 11 Dashwood Square, Newton Stewart, DG8 6EQ, Premises Licence Holder Robert James Maxwell, report by the clerk to the board. Can I pass this over to the clerk, please?
Thank you, convener. So just from the outset, just to remind yourselves that this is a distinct legal hearing from that which has preceded it. So you now must cast aside, put to the side the decision that you've made in relation to Section 84A, and this is an application from the Chief Constable in relation to a premises licence review under Section 36 of the 2005 Act in relation to the premises Star Inn in Newton Stewart, and the premises licence holder is Robert James Maxwell, who is with us today. As you have received a premises licence review application from the Chief Constable and you've determined that it's not to be rejected as vexatious or frivolous, you must in law hold a hearing. The application was received from Police Scotland on the 18th of July 2024, and that application is detailed at the Appendix 1. There's also a statutory LSO report, and that is detailed at Appendix 2, and you're aware that you must in law take into account the terms of that report. Moving on in relation to the first stages, in relation to the grounds for review, you must be satisfied in law that a ground of review is established in the first instance, and the grounds of review are detailed at paragraph 3.2 of the report, namely that having regard to the licensing objectives, the licence holder is not a fit and proper person to be the holder of a premises licence, that one or more of the conditions to which the premises licence is subject has been breached, or any other ground relevant to one or more of the licensing objectives. And you will note that the police in their letter at the end advise that they wish you to take such steps as you consider necessary or appropriate for any of the licensing objectives. So in terms of your powers, members, your first step would be to ascertain whether a ground of review has been established, and if that ground of review has been established, then consider the powers on review. You're not legally obliged in law to exercise any of those powers, even if you're minded that a ground for review exists. You would require in law to ascertain that it's necessary or appropriate to make any of the orders in relation to issuing a written warning, making a variation of the licence, suspending the licence for such period as you may determine, and revoking the licence. In terms of suggested procedure, convener, you may wish to hear from the LSO to speak to the terms of their report. Thereafter, if you've got any questions, and thereafter allow the Chief Constable to speak to the terms of their report, and thereafter questions. And then after, perhaps allow Mr. Maxwell to speak to his position with questions, and thereafter allow the police to sum up their position, and then allow Mr. Maxwell to sum up his position prior to going into session.
Thanks for that, Caroline. So, Caroline, first of all, we need to declare if we've got the grounds for review. Do we do that after we hear the speakers?
Correct, convener.
No,
you would
thank you.
hear from all parties and then
Thank
make
you.
a determination whether a ground of review exists, and then consider the next step too. But I
Thank-
can guide you through that. Thank you.
Thanks for that. So, first of all, we'll go to our LSO, Julia Darrell.
Thanks, convener. Yes, just to confirm that Mr. Maxwell has held the licence for the premises since October 2022. This is obviously the first occasion that he's been brought before you for any potential breaches of hours. I work regularly with him during the course of my routine visits, and I've always found him to be cooperative and open to any suggestions or information that's given to him. So I called at the premises on the 7th of August following the application for the review and discussed various matters with Mr. Maxwell. I examined the staff training for the staff on duty on the evenings in question, so that was found to be in order. The City and Guild staff workbooks had been completed, which is what we do recommend, that it is evidence training, so I was quite satisfied with those. All the statutory signage was displayed as required. The refusals book was given to me, and on examination it did contain what appeared to be genuine interest. Discuss the drinking up time, the 15 minutes as opposed to the 30 minutes when it's in a restaurant or food setting. So Mr. Maxwell is now aware that it is 15 minutes. We also discussed a potential variation because the hours that he enjoys at present are well within the board's policy. So it was discussed that Mr. Maxwell might increase these hours. Apologies for the noise there. As good practice, we do direct licence holders at the end of drinking up time to remove all the glassware if they've got patrons within the premises waiting on taxis, that it just saves any debate that there's any consumption of alcohol taking place after hours. Other than that, I've got no other comments to make. Thank you.
Thanks for that, Julia. Do any members have any questions for Julia or LSO? Councillor Hill?
Yeah, can I just ask, 2.1.1, you stated that it's recommended that the workbooks be completed, and they all were, but you didn't state whether it was mandatory. Is it mandatory for the workbooks to be completed, or mandatory for the training to be completed, but not the workbooks? Because in this case, the workbooks are completed. So is that voluntary? Is that something that they've gone over and above and done, or is that mandatory, please?
So you're quite correct, Councillor Hill, the training is mandatory, however the workbooks are recommended. It's also reinforced in your policy statement that we ask for evidence training. So rather than just having assigned a sheet saying that the training has been done, we're actually looking for some evidence that the training has been done. And we find that the workbooks are a perfect way of evidencing the training. So on this occasion, the City and Guilds workbooks were completed and signed off.
But that's not mandatory for that to be done, that's voluntary.
It
Okay.
is. So that is above what the law is saying, but it's evidence.
Fantastic, thank you.
That's for that, Julia. Councillor Hill. Any other questions, councillors? But just to, I know that's in the chat, but Councillor Inglis has left the meeting and won't be a part of this debate or discussion. We are still court. Just for an update. So members, moving on to the next part of this item, I would like to invite Anna Boyd, please, to give the police's perception.
Thank you. This application from Police Scotland is in terms of section 36(1) of the Licensing Scotland Act to the Wigtownshire Licensing Board in respect of a premise review request for the Star Inn at 11 Dashwood Square in Newton Stewart. The application is made in terms of section 36(3)(a), whereby there's a report that one or more of the conditions for which the premise licence is subject has been breached on 2 occasions. Specifically, I'd just like to point out in relation to the letter submitted by Police Scotland, it states to alcohol to be sold on the premise only in accordance with the operating plan. Just want to clarify that I am purely talking about consumption of alcohol on the premise and not the sale of alcohol on the premise. The premise of the Star Inn is situated on Dashwood Square in Newton Stewart. The premise licence holder and the designated premise manager for the premise is Mr Robert Maxwell, who also holds a personal licence. The operating plan for the premise does not provide accommodation, restaurant facilities or bar meals. It is licensed for on-sale hours, sales with core hours being Monday to Wednesday 11 AM till 11:30 PM, Thursday, Friday and Saturday 11 AM to midnight, and a Sunday 12:30 PM to 11:30 PM. This application focuses around 2 incidents, the first one being at 20 to 1 on the morning of Saturday the 15th of June, whereby Police Scotland officers have been on mobile patrol within Dashwood Square in Newton Stewart and noted the Star Inn still to have patrons within it. Those officers were of the belief that the premise was licensed until midnight and thereafter attended at the premise and noted about 20 persons within, many drinking alcohol at the bars and tables. Some had full pints of lager and some were drinking from what appeared to be Budweiser bottles. They also noted that karaoke was ongoing. The licence holder, Mr Maxwell, was at the front door of the premise. He was asked if he had an extended licence for this date and stated that it did not, but he advised officers that his licence for the premise was until midnight. Officers left the area to conduct inquiries regarding the terminal hour and confirmed to themselves via checks that it was a midnight closure core hours on a Friday night. CCTV footage was obtained by officers from the surrounding area which showed persons leaving the premise between 00:46 hours and 00:53 hours. On Thursday the 4th of July, police contacted Mr Maxwell on his mobile telephone and requested to speak with him regarding this incident. At that time, Mr Maxwell has responded that he would be requesting his solicitor's attendance before speaking with the police, and furthermore that the police should not contact him regarding any further incidents, and he would no longer aid the police with their inquiry going forward. Due to the observations of officers on that morning of the consumption of alcohol after midnight of the terminal hour of the premise, Mr Maxwell was cautioned and charged under section 63(1) of the Licensing Scotland Act for allowing the consumption of alcohol on his premise at the Star Inn out with the licensed hours. Mr Maxwell replied to the charge, "We weren't serving alcohol at that time and I was in the central by 00:35 hours. It was just bar staff in decorating." The second incident in relation to this report occurred at 00:40 hours on the morning of Saturday the 29th of June 2024. Again, Police Scotland officers were on mobile patrol in Newton Stewart when they noted the Star Inn still to have patrons within. About 15 persons were observed by the police officers, many drinking alcohol at the table and bar within the premise. When asked, the licence holder, Mr Maxwell, stated again that he was licensed until midnight. At 1:45, the police officers approached Mr Maxwell and asked him to remove the patrons from within the bar, at which point he declined to do so. It is reported that he adopted a hostile and combative demeanour towards the police at that time. Police officers thereafter removed the patrons from within the premise with some minor resistance, which I believe to be verbal at this time. During this, Mr Maxwell made no effort to assist the police in asking anybody to leave his premise and stated it was a private family function and he would be contacting the licence board to take up the issues. Due to the officers' observations of the clear consumption of alcohol after the terminal hour of midnight, Mr Maxwell was cautioned and charged under the Licensing Scotland Act section 63(1) for allowing the consumption of alcohol outside his licensed hours within his premise of the Star Inn. As both the premise licence holder and the designated premise manager, it's Mr Maxwell's responsibility to ensure that he is fully conversant with the operating plan of the premise that he is in charge in. By being found with the premise open in contravention of its licensing hours, not once but twice by police, Mr Maxwell has shown a complete disregard for the licensing law. His refusal to help officers clear the premise when asked to do so, and his belligerent attitude falls short of the behaviour which can be reasonably expected of the licence holder with one working within one of the busier premises within Newton Stewart. At this time, the reports have been submitted by the police to the Procurator Fiscal and the matters remain sub-judicial. I request the Licensing Board considers the grounds for review and takes any such steps in relation to the licensing objectives in terms of the operating premise licence for the Star Inn at Newton Stewart. Thank you.
Thanks for that, Anna. Members, do we have any questions? I imagine a lot of questions were probably answered in the previous item. Councillor Hill?
Can I just ask, it states that the police asked Mr Maxwell to remove the patrons from the premises. As stated by law, they shouldn't be in the premises, but they shouldn't be in the premises drinking after 12:15, but there's no law to state that they can't be in the premises. It's just good practice. Is that correct, please? Or is it actual law that they cannot be in the premises even if they're not drinking after 12:15? Because I'm a bit confused by that. So if I could just have the actual law regarding that, whether it's good practice or it's by law, so that we can be really, really clear and transparent on this, please.
That's right, Councillor Hill. Anna?
So my understanding is that the consumption of alcohol is a breach of the core licensing hours, which makes it a criminal offence. The persons being within the premise, there is nothing preventing them being within the premise if they're not consuming alcohol or being sold alcohol. So there's nothing stopping them being there. The offence is being committed by the person that is selling the alcohol and the premise licence holder for allowing that alcohol to be sold. The actual persons within it are not committing offence by being there, unless there is any other breaches of the Licensing Scotland Act that they may be breaching. Police Scotland do have the power to close a premise if we have terms within the Licensing Scotland Act that we believe that premise is either causing issues or breaching the Licensing Scotland Act. Sorry, I'm not explaining this very well. So we can enforce a closure which would include the removal of persons within the premise. We have not done that on this occasion. We have looked to speak to Mr Maxwell and have that premise closed by him as we believed it was operating out with its licensing hours. A further step would be a police closure, which we have not done as the premise did close on discussion with both Mr Maxwell and those within the licensed premise.
Thanks for that, Anna. A lot of questions actually raised just from that answer, but Caroline Trainer, our licensing solicitor, would like to come in.
Thank you, convener. It was just to hopefully assist, if I may, just to focus the minds a wee bit. In relation to this application, the first step you need to ascertain is, has a ground for review been established? And of course, you're only hearing from the police at the moment. And it was just to advise that one of the grounds for review is alleging that there has been breach of a condition of the licence, and the police in their letter advising that their view is that Mr. Maxwell has breached a mandatory condition of his licence, in that alcohol is to be only sold in the premises in accordance with the operating plan. Now, on the other hand, you've heard from the police that they're concerned with consumption of alcohol. So just to advise that the breach of the condition that's stated in the police letter pertains to sale of alcohol. Sale of alcohol can only take place in accordance with the operating plan. However, in a review hearing, you can also find, once you've heard all of the parties presenting their case, another ground of review. Now, given that the police are alleging that there was consumption of alcohol out with that, out with the licensed hours, out with the 15-minute drinking up time, i.e. after 12:15, and they've cited a condition that pertains to the sale of alcohol. There is also under a mandatory condition 2.3 is where any other activity is carried on in accordance with the operating plan. So one of the conditions can cover consumption, and the police are stating a condition that pertains to sale, but then they're, on the other hand, they're advising that there's been, in their view, an alleged breach of section 63 based on consumption. So it is open to yourselves. You have to find a ground of review in the first instance, and it is open to yourself to find another ground of review that's not detailed in the police letter. And there is a mandatory condition that states that any other activity has to be taken place in accordance with the operating plan, and any other activity could capture consumption of alcohol. I hope I'm assisting here, because there is a lot of information going on here. It's just the police are talking about alleged consumption out with your licensed hours, but they're in their letter they're referring to a condition that pertains to sale only. But there is another condition where that could catch consumption, and you do not need to go along with the ground of review that the police are alleging.
That's a lengthy answer. Councillor Hill?
So apologies.
Yeah, thanks, convener. Yeah, I'm a wee bit confused by this, because it states point 2 that it's to be sold, but when the police officer was speaking there, she said it wasn't to be sold, it was for consumption, but then she referred back to it being sold in a reference. So I'm a wee bit confused whether it's for sale or for consumption. I'm really confused by this, which one it's actually for.
Thanks, Councillor Hill. Caroline, can you assist?
Yes, I'll try and assist in more simplistic terms. So in relation to this application, in law, you must first find that a ground for review has been established. That's your first step. And the grounds for review are detailed at paragraph 3.2 of your report. One of those grounds for review is that there has been breach of one of the conditions of the licence. Okay, one of the mandatory conditions, a mandatory condition that attaches by law and not by the board, is that alcohol can only be sold on the premises in accordance with the operating plan. And this is the condition that the police have detailed in the first page of their letter, that their view is that there has been a breach of this condition. On the other hand, as I understand it, the police are not alleging that there has been a sale of alcohol out with licensed hours. They're alleging that there has been a breach of section 63 in relation to consumption of alcohol out with licensed hours. So consumption of alcohol out with licensed hours is a statutory offence in terms of section 63. Consumption of alcohol out with licensed hours is also breach of a mandatory condition that attaches to the licence in law, but it's not the mandatory condition that's detailed in the police report, because that condition talks about sale. However, if there is consumption of alcohol out with licensed premises, that is breach of another mandatory condition that's not detailed in the police report. And in a review hearing, it is open to yourselves to determine whether a ground for review exists that is not detailed in the police report. So it's just, I appreciate there may be a confusion in relation to, we're talking about sale of alcohol here or consumption of alcohol. My understanding is that the police are talking about consumption of alcohol, but they've stated that there's been breach of a condition of the licence that refers to sale. So I would suggest if the police are talking about consumption of alcohol and that there's been a breach of section 63, that it may be that the condition that's detailed in the police report that refers to sale is the wrong condition that's been breached, the wrong condition that's been detailed if the police are talking about consumption. I think you'd want maybe to have clarity, convener. My understanding is the police are talking about alleged consumption of alcohol out with the licensed hours and beyond the 15-minute period, but they've stated a condition that refers to sale. But there is another condition that can encapsulate consumption. And you can find, if you have evidence after hearing, of course, from Mr. Maxwell, you may wish to consider that it's the other condition that pertains to consumption and not the one detailed in the police letter.
Thank you, Caroline. I'm going to say that you shed some light on things, but I'll let others decide. So I've got a question for you, Anna, and this is, so if it's not illegal to be in the premises, not drinking after hours, but it is if you've got a drinking game, and the police did not perform a mandatory closure, which is within their rights. What right do the police have to chuck out Mr. Maxwell's customers if they have the drinks taken off them, and if you're not performing a mandatory closure?
First of all, I'll just clarify what Ms. Traynor said there, that the 100% agree with the terms of what has been explained. Our letter states consumption. We are only talking about, our letter states sale, sorry to confuse things, and we are only talking about consumption. So there's a number of steps. It's maybe myself that caused that confusion with stating that we can do a closure. There's a number of steps that police officers will always go through to engage with patrons prior to using any legislation under Licensing Scotland Act, specifically Section 97, which allows us, in the interest of public safety, to close a premise. And that will always go through engage and education first. And in this case, we have engaged with the patrons. My understanding is there has been no physical removals. There has been requests and conversations occurred, which has resulted in those patrons leaving the premise. We have not physically removed anybody from that premise at that time. So through our engage and education steps, that pub the patrons within that pub have vacated that pub prior to us requiring to use any legislation to close it. In the interest of any public safety or any issues. We retain using that legislation for significant issues of violence and disorder, which we do not have in this case. We simply have consumption of alcohol out with the core hours, which I will still maintain and reiterate is a criminal offence for which a report has been submitted to the Procurator Fiscal.
Thanks for that. Right. Councillor McCarman, your hand went up.
Yeah, I just wasn't know whether it was appropriate or not. Convener, I'd like to request a private session when it's relevant.
We're not in session at the moment. Councillor McCarman would have to listen to all the grounds that we've got, and then I think we need to decide in public if we have the grounds for a review.
Right, cool.
Am I correct with that, Caroline? Just briefly.
Yes, convener, perhaps just jumping the gun a wee bit. We need to hear, you need to conclude your questions to Anna Boyd from Police Scotland, and thereafter allow Mr Maxwell to state his case, and thereafter allow Anna Boyd to sum up on behalf of the police, and thereafter allow Mr Maxwell to sum up his position prior to going into session. And then at that stage, you could make a determination as to whether you wish to privately deliberate, as you have the legal power to do so.
Thank you for that, Caroline. So members, any more questions? I'm not seeing any hands going up. So Mr Maxwell, it's open. The floor is open to you to give us your perception on the night.
As I said earlier, the 14th of June, it was only bar staff that were in. There's maybe about half a dozen. They were decorating the pub for my wife's birthday, 40th birthday party on the Saturday. The police did not enter my premises at all. My front door was pushed over. I seen the police van pull up and I went outside to speak to them. The 29th, I've got a bit of confusion here with the 29th. It was actually the Saturday night, the 29th, that the police came into the early hours of Sunday morning. Wasn't the Friday into the Saturday. The Friday night I was working myself. The Saturday night Miss Clucky was on, and that's the night that the police came in. It was Saturday the 29th into Sunday the 30th. So I don't know where the confusions came from there on that they were in. It was a Friday into the Saturday, because it was the Saturday into the Sunday, which some of the statements I've already told you. And as I say, the police did come in. They got a bit abusive with some of my customers, swearing at them, telling them to get out of the pub. That's when I said I wasn't throwing anybody out. I mean, that it just, as previously you heard it previously before, nobody was drinking alcohol. The glasses were on the bar, ready to go into the glass washer. Thank you.
Thanks for that, Mr Maxwell. I'm just reading in our chat that we have two members that look like they're going going into other meetings at 12:30, which would mean that we're not quorate. What should we do, Caroline? Oh, Councillor Hill.
Are we in session, convener? Because
No.
I'd like, no, okay.
So, Caroline, what is the process here?
Thank you, convener. You'll note that I have just stated in the chat that if both councillors go, then this meeting is not quorate in law and would not be able to continue, and would therefore fall. I would have to give thought to whether it would be appropriate at a future date to start all over again at a future hearing date when members are quorate. I can see Councillor McCammon coming in, however.
Councillor McCammon?
Yeah, I'm happy to delay the other meeting. So, and as far as I'm concerned, it's, yeah, and Chris has just done the same. So yeah, I'm happy to send late apologies.
Thank you, members. We'll try and do this quickly. So members, any questions for Mr Maxwell? I'm not seeing any questions. So members, I'll invite I'll invite Anna Boyd from Police Scotland to sum up.
Thank you, convener. As previously stated, Police Scotland have supplied information in relation to what we believe to be two clear breaches of the core licensing hours, where Mr Maxwell at the premise of the Star Inn in Newton Stewart has allowed the consumption of alcohol out with his core hours of the premise, and we request the board to consider any such actions necessary to address this matter.
Thank you for that, Anna. Julia Farrell, any summing up from you?
Convener, I've really nothing further to add to my report. Thank you.
Thank you. Mr Maxwell, would you like to sum up at all?
No, I'm fine. Thank you very much. I think I've said it all.
Thank you, Mr Maxwell.
Thank you very much.
Members, we're into session. Do we have any ideas? Councillor Hill?
I don't feel that we have grounds for a review. I think that the CSO has been in and you know, she's quite happy. I think that the premise holder has gone over and above with making sure workbooks are filled in. And I think the license holder is aware now of his licensing hours and, you know, what he needs to put in place further. Thanks.
Thanks for that, Councillor. Councillor McCarman.
Yes, convener, I concur with Councillor Hill's comments. Thanks.
Actually, sorry, members, just for the avoidance of doubt, we have we found no grounds to take this forward into a review or a hearing. Sorry, am I correct, Caroline? That's the stage we're at right now.
So you're now in session, and I would suggest the premises license review hearing is a two-stage process. The first step is that you must find a ground for review in law, okay? And those grounds are detailed at paragraph 3.2. That the licence holder, having regard to the licence objectives, is no longer a fit and proper person to hold the licence. There has been a breach of one or more of the conditions to the licence or any other ground relevant to one or more of the licence objectives. You must find that a ground of review has been established in the first instance. If a ground for review is not established, it all falls then and no action is taken. If you find that a ground for review has been established, then you would go on to the second stage and decide what action, if any, you may wish to take. And I think for simplicity, it may be the case that you, at this juncture, that you focus on the first stage. Has a ground for review in law been established? The police are alleging that there has been breach of a condition of the licence, namely that alcohol can only be sold in accordance with the operating plan. You've heard from the police that they have said that they're concerned that there has been alleged consumption of alcohol out with licensed hours. I'm suggesting that there is also another condition in terms of the law that attaches to a licence that covers that consumption of alcohol, and it's not the condition that the police have put on their letter. And then on the other hand, you've heard from Mr. Maxwell, who's advised that there was no consumption of alcohol out with the after 12:15 on any of the two dates. But your first stage, drawing you to paragraph 3.2 of the report, is there evidence before you, having heard from both parties, that a ground for review has been established?
Thank you, Caroline. Councillor Hill.
I don't feel that the evidence in front of me is grounds for review, so I don't think we need a review. Thank you.
Thank you, Councillor Hill. Councillor McCowan.
I agree, convener.
Thanks for that, Councillor McCowan. I am in mind to agree as well that we have no grounds for review here. Councillor Dashper.
Yeah, happy to agree with the consensus, convener.
Thank you very much for that, Councillor Dashper. Caroline, can you outline what's been agreed so far, please?
Just to articulate my understanding, convener, is that the consensus of the board that no ground for review has been established, as there is no evidence to suggest that the licence holder is not a fit and proper person to be the holder of a licence. There is no evidence to suggest that there has been a breach of a mandatory condition of the licence, whether that is sale of alcohol can take place in accordance with the operating plan, or any other activity can only take place in accordance with the operating plan, which would capture consumption of alcohol, and that your views that there is no evidence to suggest that any ground relevant to one of the licensing objectives is engaged. Is it the case that it's a unanimous decision of the board that there is no ground for review established because there is no evidence to support that, just to clarify?
I think you just clarified it, yes.
Yes, thank you, convener. And if that is the case, then the matter would fall now. So I will just reiterate today's decision of the board to Anna Boyd from the police and also to Mr. Maxwell. The board are of the view that there is no evidence to support that there is any ground for review in this instance, whether that's the licence holder not being a fit and proper person to be the holder of a licence, that there is no evidence to suggest that any of the conditions of the licence has been breached, and that there is no evidence to suggest that any other ground relevant to one or more of the licensing objectives is engaged. So in that instance, because the board has unanimously decided that no ground for review has been established, the matter stops now in law, and there's no action taken. And just to advise in relation to that decision, both the police and the licence holder can appeal that decision within 21 days of today's date to the Sheriff Principal, and that decision of today's board will be notified in writing to both parties in early course. Thank you.
That's right, Colin. Members have no other business, so that's today's meeting closed, and we come back on the 12th of September. I'll see you on the 12th.